I'm Cornell Clayton. I'm director of the Foley Institute here at WSU, and on behalf of the Institute, I want to welcome you out to our event today. Before I introduce our speaker, I just want to mention we have our last event coming up next week. We have the legislators from the 9th District. That's our representatives here in Pullman. They'll be doing their annual legislative preview session for us to talk about what they think is going to be interesting issues for the legislature next in the spring. But right now, we are very fortunate to have with us Bob Ferguson, who's a good friend, and he's Washington's 18th Attorney General. Since taking office in 2013, Bob has created a dedicated unit within the Attorney General's office to enforce the state's campaign finance laws. He's been very successful at doing that. He's created a Council for Environmental Protection, which pursues both litigation, both criminal and civil cases, and he's created the office's first ever civil rights unit. In addition to his high-profile public lawsuit against the Trump administration, which successfully blocked the administration's travel ban last year, he's twice sued the Obama administration over cleanup and worker safety at the Hanford Reservation site. He's also named one of Time Magazine's 100 most influential people in 2017. Bob received his JD from New York University School of Law in 1995. He earned his BA in political science from a lesser university across the other side of the Cascades, where he's also the student body president there. And like I said, he is a very good friend of the Foley Institute. He comes every year. It makes time out of his busy calendar. And so we put him on the cover of our new newsletter so you can get signed copies of this later. Join me now in welcoming Bob.
Thanks so much, Cornell, and please, all the folks who work here at the Foley Institute do great work on behalf of Washington State University and the community. Give a big round of applause to Cornell and his entire team. It's great to see you all again. It's kind of become an annual tradition, which is a lot of fun, and so it's great to be back. One thing I'll get out of the way first is the Time Magazine thing that Cornell mentioned. Time Magazine does have this 100 most influential people in the world list, they put out. And I'm one of 7 kids. There's 6 boys, 1 long-suffering sister in my family of 7, right? It's a big Catholic family. And when that came out, this Time Magazine 100 list, my oldest brother, Tom, called me up on the phone. He lives in California. He said, "Bob, it's quite a promotion considering you're not even the most influential person in our family." That's what big brothers are for at a time like that. I'm going to dive in, and I'm going to focus on a couple cases related to the Trump administration that are going on. I did this last year as well. I think last year I focused on cases we had regarding Dreamers, protecting Dreamers in our state, which has continued to be successful. I can't remember what the status was a year ago when I was here, whatever it was, but we've still been successful in the courts, but it is being appealed up, that case, and will undoubtedly end up before the United States Supreme Court. There's a couple different cases challenging President Trump's decision to take away protections for Dreamers, so we don't know which case will be the one that ends up before the U.S. Supreme Court, but that is still ongoing. And I think I also spoke maybe about the first travel ban as well. And of course, we were successful in stopping the first travel ban. The president then issued a more narrow second travel ban, then a more narrow still third travel ban. That third one was challenged by Hawaii and was eventually upheld by the U.S. Supreme Court 5-4. So I'm happy to chat about those cases, or really any cases, but I'm going to focus on a couple cases here today. Now, we have filed, so far, Washington State has filed 32 lawsuits against the administration. That's a lot of litigation against anyone or anything, which I'm mindful of. That's a lot. I also want to emphasize I'm also mindful that people have strong views about that, in support or opposition, depending on one's perspective. A couple thoughts. So one is, they are obviously decisions that I make. I don't delegate that to my team. I have a great, fantastic team. They advise me on all these cases. And by the way, I'm happy to chat about, how we make decisions in general. Feel free to ask anything right to the question period. But those are decisions I make. And in those 32 cases, one thing about litigation is, unless a case settles, and none of these cases really with the administration settle. Their cases are going to go to court and a judge is going to decide. We've had 15 of those cases, we've had decisions from federal courts. So far in those 15 cases that have had decisions, Washington State's won all 15 of those cases. So literally 15-0 in those cases. Sometimes I'm asked, "Hey Bob, why do you file so many lawsuits against the Trump administration?" I think the better question is, why doesn't the Trump administration better follow the rule of law and the Constitution when enacting policy? I think that's the better question. Take my word for it, as a lawyer, it's hard to go 15-0 in any area of the law anytime. Just like it is for a football team, you pick the endeavor, right? It's just difficult to win over and over and over again. That, in my view, something fundamental is going on. Do I think I have a great legal team? Yes. But do I think it's partly that the administration does not go through a rigorous process in examining these executive orders or these decisions before they put them out there? I do believe that, and happy to chat more about that. So let's get started. I've got a handful of slides I'll zip through. So these are, sometimes people ask, hey, how do you decide if you're going to file a lawsuit against the president? And I might even have this slide up when I was here a year ago, I can't remember, but having now had a lot of litigation with the administration, and two against the Obama administration, Donald Trump was not the first president I filed a lawsuit against. Barack Obama was, a man I deeply respect and admire. So the occupant of the White House or their party affiliation is really irrelevant to me in making a decision to file a lawsuit. These are the three questions I ask every time. Are Washingtonians being harmed? Do we have good legal arguments? And can I, as Attorney General, bring the lawsuit? That last one is, do I have standing as Attorney General? So think of it as, take a case like the Dreamers case. If you're a dreamer and the protections you've had to be in this country lawfully are removed, you can bring a lawsuit because you are being harmed, right? You have standing to go to court and say, hey, judge, I want to stay here in the country and I think I've got rights to do that. It's less intuitive sometimes whether I, as Attorney General, can bring a lawsuit on behalf of the people of the state of Washington. I'll spare you the legal details of that, but it's an issue called standing, whether I can be in court on behalf of the state. And that's a big issue for us. When we look at potential litigation of any kind, but especially against administration, that's a big one. When I sued the Obama administration on Hanford, the Obama administration said, hey, Bob Ferguson cannot be here as Attorney General to bring a case on behalf of the workers at Hanford. Okay, they literally argue that they lost that argument. That is a regular issue that we face. So from my perspective, these are the relevant questions. If the answers are yes, yes, and yes, then I'm interested. If there's a no in there, and there often is, to be honest with you, there often is, then we're not filing. And so for me, it may seem like a complicated process. And in a certain sense it is. Obviously law can be complicated, but the decision-making process, it's really not, right? I feel as long as I'm staying focused on these three questions, then I think we're bringing the right kinds of questions, right kinds of cases, and will help us be successful. There's lots of other interesting questions, right? What does it mean politically? Well, that may be interesting for me after 5 o'clock, but it's not relevant to making a decision whether to file a lawsuit, right? There'll be a question of the resources in the office. Who's gonna handle the case? Happy to chat about that if you're curious. We can make those decisions after. We decide we're going forward, we'll figure out the resources afterwards. That's a big part of my job as well. But that's what I focus on in bringing these cases. Now, I mentioned we have 32 cases. One thing I should just mention quickly is that we obviously, in almost all of those cases, we team up with other states, okay? Sometimes it's just a couple states, sometimes it's upwards of 15, 16, 17 states with Democratic AGs, almost exclusively. In every one of those lawsuits, there's always one lead state. With one exception, the Dreamers case has 3 co-lead cases because it's a very complicated case. Washington, New York, and Massachusetts are sort of sharing it equally. But typically, on almost every other situation, one state is the lead, and they are doing 95% of the work. Okay, one state is just more efficient that way. The other states are supporting with declarations, that type of thing, and adding heft to the lawsuit. That gives it some national scope as well. But one state is the lead. So of the 32 lawsuits that I mentioned, Washington's the lead in 10 of those. That's a lot. We're not the largest AG office in the country. We're not like New York. We're not like California. But we're the lead on 10. And those 10 tend to be, from my perspective, some of the most high-profile, consequential lawsuits. The first travel ban, the transgender military ban, one I'll talk about here in a minute related to 3D printers, the family separation lawsuit that we have, some pretty big issues that we're the lead on. And so that is something else that I have to decide, hey, what kind of cases should Washington be the lead? That can be based on all sorts of factors like the expertise in my office, and do we have the bandwidth at any particular moment in time to be the lead state as well. So there's a lot of litigation we have. I'm going to focus on 2 issues, and the first one's a case related to 3D printers. The second one's going to be a case in which we're not actually a party to the case. We have filed a brief, something called an amicus brief, a friend of the court brief, in support of the state of Maryland. The state of Maryland is challenging whether Mr. Whitaker, who Donald Trump appointed as Attorney General, can serve in that capacity. There's been a big issue whether or not he is constitutionally able to serve as Attorney General or not. Because that one's in the news so much, I thought it might be interesting one to give you a perspective on it. Just want to be clear, we haven't filed a lawsuit on that issue, doesn't mean we won't in the future, but we are assisting Maryland by filing a brief in their case, and so that'll be the second one I talk about. So let's get started on 3D printers. So first, what is a 3D printer? Many of you may know it's a machine that can create a physical object from a three-dimensional digital model, and 3D printers are becoming more accessible to the public. The cost can be anywhere from, I think you see there, from $200 to about 10 grand. So there's a range in price for these things, but they're becoming more accessible to the public. This fellow here is a guy named Cody Wilson. He has a company called Defense Distributed. He's a self-described crypto anarchist. That's how he describes himself. And he designed a gun that, created by a 3D printer, works. Okay, so it's a plastic gun that you can download information using a 3D printer and print out a gun that is functional, that works. That doesn't work as well as a regular gun, of course not, but it shoots bullets, right? It shoots bullets. 3D guns are sometimes called ghost guns. There is a reason for that. There's no serial number, no background checks associated with them. They're printed out of your home. There's no waiting period. All the checks that we have as a state, for example, right? Those don't exist with a ghost gun because you're printing it out in the privacy of your home. And many 3D guns, these ghost guns, I went through SeaTac Airport earlier today, of course, to get here, and went through the security check. You got a plastic gun, maybe those bypass won't be picked up at security checks, at your Seahawks football game, or going through an airport. So there's a reason why they engender a lot of thoughts from folks about, from a public safety standpoint. So Mr. Wilson, he created this company, and he put manuals for creating these guns on his website. So he made it publicly available for anyone to download that information, and if they have a 3D gun, they can print out one of these ghost guns. Under Barack Obama's administration, they filed a lawsuit challenging that. Okay, so Barack Obama's administration said, hey, that violates certain federal laws that relate to national security. I'll spare you some of the details around this, it gets complicated in a hurry, but the Obama administration said, hey, you cannot do that. And they went to court in Texas. That's where Mr. Wilson resides, that's where his company is. So that lawsuit was started in 2015 by the Obama administration. And the federal government successfully argued in court, in federal court, that by posting this information online, that violated federal laws. I think I've covered all that, so a lawsuit got underway. So the government, while Barack Obama is president, argues that these 3D downloadable guns could be used to threaten U.S. national security, U.S. foreign policy interests, or international peace and stability. Now, you'll note the date on that is April 2018. So that's when the State Department, the government was arguing that. So the lawsuit went on beyond when Barack Obama left office, so the Trump administration inherited the case. And they continued to go forward with the case, winning at every level of the court system. And in April of 2018, this was literally part of their argument to the federal courts. Hey, this is why we have these rules. This is why this guy can't post this stuff on the internet, okay? Somewhat remarkably, a short time after April 2018, I think it was in June or maybe it was in July, or June or July, the federal government unexpectedly, quietly, despite having won at every level of this litigation, by the way, okay, settled with Cody Wilson, entered into a settlement agreement with him. The settlement agreement allowed him to legally post that information on 3D guns on the internet, to do that legally. I cannot, if you ask me the question of why they did that, I cannot answer that question, okay? They were winning at every stage of that litigation. But for whatever reason, they entered into agreement that allowed him to legally post that on the internet. My next two slides are out of order, so I'm going to skip and come back to that one. So this is Josh Shapiro, Pennsylvania Attorney General. Great guy, great Attorney General. This maybe is a good example of how AGs sometimes communicate in these issues. It's not unusual for me to pick up the phone and call someone, a colleague like Josh, right? Or Javier Becerra in California, or vice versa. If something's going on, right? If we're thinking about doing something. So when this became public, this settlement became public at some point. And in that settlement, it said that that company could post that information on August 1st. And now we're well into July, it's late July, and this is like a few days away where he'll be able to post that information legally. So I hear about this, and we start thinking we may have to go to court to try and get an injunction to stop that. I called Josh up, and he's been a great ally in a number of cases, and he was also thinking about going to court as well. He filed a lawsuit in Pennsylvania. And so literally on the weekend leading up to August 1st, I can't remember what day of the week August 1st is, I think it's a Tuesday, because that weekend they were literally before a judge in Pennsylvania that weekend. The judge, I think he was only seeking to block this from happening in Pennsylvania. In other words, that you couldn't post anything on the internet, essentially access it in Pennsylvania, which is kind of odd, right? Something like it'd have to be national in scope. But he was not able to get national relief, okay? My team, meanwhile, was working around the weekend, throughout the weekend, to put together our own litigation that we're going to file in federal court in Seattle, the Western District of Washington. So this is Jeff Rupert, one of the attorneys on my team. A lot of people worked on this case, as you might imagine. Big case, complicated case. A number of states joined us, and we went to court on Monday, the day before this individual could post his information online, and we were asking for a restraining order. In other words, for the court to say, hey, before I have the chance to go through the normal legal process of getting a discovery process and documents being exchanged and lots of time to think about briefs and file motions, what we're asking the judge to do is short circuit all that, and until, judge, you have time to make a decision on the merits of the case, in the meantime, shut this operation down. Now, it's not easy to get that relief for obvious reasons. Judges are reluctant to do that for obvious reasons. You're asking a judge, right, on kind of short notice, to make a really quick decision to stop something from happening that's already in place. And judges are, with good reason, are reluctant to do that. The burden to meet in order to get that to happen is very high, okay? So we went to court before Judge Lasnik, a federal judge in Seattle, and Jeff handled the oral argument at that argument, saying exactly that. Hey, Judge, the threat to public safety, right, and other reasons really necessitates you telling this guy he cannot post that information the next day, because bad things will happen in the meantime. So put that in place until you can reach a final decision. So we were before Judge Lasnik, a longtime federal judge in the Western District of Washington. So our arguments are, and I won't go into too much detail around the arguments, but in almost all the cases we bring against the administration, we typically, speaking at a very high level, we typically have two buckets of arguments, almost always. One is we're asserting that the government has violated federal law, okay? Statutes that we have, just laws that Congress has enacted, federal laws. The other is typically we're saying they've violated some aspects of the Constitution itself, right? So you got statutory arguments and you've got constitutional arguments. In most of our cases, there are many arguments we're making, as you might imagine. So as an example, for the Administrative Procedure Act, which is, whenever you talk to any audience about the Administrative Procedure Act, you are sure to put people to sleep, right? It may not sound very exciting, right? The APA, the Administrative Procedure Act. I can assure you that the APA is a critical statute for me, for my team, and it's kind of what it sounds like. It's administrative, it's procedural, but it's important. What it requires is, speaking at a very high level, is, hey, before your federal government can go off and do stuff, there are certain procedures they have to follow before they do it. It makes sense in a way, right? Let's come an easy example, public comment. They often have to elicit public comment before they issue rules on things. That makes sense. The public should be entitled to weigh in on important issues that the administration might be making, and so Congress has said, hey, you want to do things, administration, great, but you got to hear from the public first. Sometimes they require a cost-benefit analysis, a study done of the issue. Sometimes they say, you know what, if you're going to do something administration that impacts businesses, small businesses, you've got to have some process where small businesses can give feedback on what this issue might mean to them. There's a whole host of things that that the federal government must do. Think of it as my wife and I have 10-year-old twins, Jack and Katie. So when they do their math homework at home, right, there's the problems on the left-hand side, and there's white space over on the right. And the white space on the right is for Jack and Katie to show their work. That way we know they didn't pick up my phone, right, and use the calculator and punch in the question and then just write the answer. The teacher wants to see Jack and Katie show their work on how they arrived at that answer. So they know the teacher knows they got there legitimately, right? The Administrative Procedure Act is kind of the same thing. The administration has to show their work. How did you arrive at that decision? There was a thoughtful process everybody can understand and is fair to everybody. That's the Administrative Procedure Act in a nutshell. As one example, on this case, the law requires that before things like these ghost guns can be put on the internet, right? Things that the administration has said jeopardize national security, you have to, for example, give Congress 30 days notice. Congress deserves to know if you're going to make this big change and put something like that out there, you're going to make a change in well, what's protected and what's not, you got to give Congress a month's heads up. Seems reasonable. They didn't do that. You have to get the Defense Department their approval, their okay before you do it. They didn't do that. So we went to court, and some of our arguments were the Administrative Procedure Act. So this has been a go-to argument for us over and over and over again. Honestly, if I had to pick one single act, that we win of those 15 cases we win on, the Administrative Procedure Act, which sounds like the least sexy thing possible in the law, right? We're not talking about equal protection or due process or the First Amendment or all kinds of, those things are critically important, don't get me wrong. But hey, sometimes what the law is, you're making sure they're following all aspects of the law. And hey, it's not just the Trump administration. When Barack Obama was president, Republican AGs challenged him frequently, dozens of lawsuits. It's worth pointing out those Republican AGs lost far more of those lawsuits than they won, by like a 2-to-1 margin. But Barack Obama had a big immigration executive order that he put out. A Texas AG, Texas Attorney General, Republican, challenged that in federal court in Texas, and it was struck down not because of some big constitutional reason, but because of, you guessed it, the Administrative Procedure Act, right? So those we thought were very strong arguments for us. The other arguments we have are constitutional violations. The 10th Amendment. Washington State, as one example, we have many laws that put certain restrictions on gun ownership, right? You got to be 18 years old to have a gun. You got to be 21 to buy a handgun, right? There's certain background checks that are done. Certain folks aren't allowed to have guns. Felons, domestic abusers, right? There are limits on who can carry a firearm. Well, if ghost guns are allowed to be put on the internet and downloaded on a 3D printer, that bypasses all those state laws we have put into effect. So we have constitutional arguments around that hey, we as a state are entitled to certain protections that we think are important for the people of our state. This bypasses all that in a way that we think violates the Constitution. So we go before this federal judge. I think it was a Monday. It was certainly the day before August 1st. It was the last day of July. And we literally are saying to the judge, we're asking you to issue an order right now to put a temporary restraining order in place. And Judge Lasnik agreed. In his order, he wrote, it is the untraceable and undetectable nature of these small firearms that poses a unique danger. And we agree with that. Now, I want to emphasize that does not mean the case is over. It's not really even a decision on the merits of the case. He's not even saying we've won. He's simply saying, hey, everybody, until I, Judge Lasnik, have a chance to read more detailed briefs and get some more information, I'm simply blocking this individual from posting that information. Okay, so the case is going on. It is worth pointing out, though, judges, in order to issue a temporary restraining order, one of the requirements is a judge has to determine that the state of Washington, in this case, is likely to prevail on the merits of the case when the judge eventually reaches the merits of the case. So that is you've got to have a very strong case in order for a judge to issue a restraining order. Doesn't mean he has to rule that way. There could be new information that changes his mind, but in order to grant us our temporary restraining order, he had to reach the conclusion that we were likely to prevail when we get there. Now look, there are not many things that Donald Trump and I happen to agree on, but actually this issue is one of them. Here's a tweet from Donald Trump, right in the middle of all this. I'm looking into 3D plastic guns being sold to the public. Already spoke to NRA, doesn't seem to make much sense. I agree with that. So one question I have is, the Department of Justice, who exactly are they representing? No, in all seriousness, right? I mean, is the president the client? Typically you would think the president's the client here. Well, that's what the president had to say about it. I literally wrote a letter to Jeff Sessions when he was the Attorney General saying, why do you keep fighting this? Because they're fighting it even now. They haven't given up by any stretch of the imagination. Why do you fight this? Well, what client wants you to fight this? What client thinks is a good idea, right? I never got an answer to that letter. But that was what the president posted, which I think raises its own interesting questions, right? I'm often asked, why is the administration doing X or not doing Y? I can't answer that. Sometimes what's coming is contradictory, right? Where the Department of Justice is fighting us hard in court on this issue, but yet the president himself has put out a tweet along these lines. Just as sort of to wrap up the Cody Wilson. So this is arrested in Taiwan. That's not right. He was arrested. Well, I mean, he was. Maybe that actually is right. So he was being accused of sexual assault charge against a minor. He fled to Taiwan, and then they were able to get him in Taiwan and bring him back. So I guess technically maybe he was arrested in Taiwan. I guess that's right. But it was for alleged conduct in Texas, I believe, with a minor, a sexual assault. He fled to Taiwan. He wasn't picked up in Taiwan, so I believe he's in jail as we speak. But his company still exists, and they're part of that litigation as well. So that's one example, right, of one of the lawsuits that is still ongoing. So of those 15 cases I said we've won, that's one of the 15. I should have mentioned 9 of those cases are over. There's no more appeals, right? Those 9 are just done. It's done as last week's Apple Cup. I'm sorry, I couldn't resist. It's done as last week's Apple Cup. I had to work it out. Oh, very great. Had to work it in. So 6 are still ongoing. That's 1 to 6. Okay. The Dreamers case is 1 to 6. The transgender military ban is 1 to 6. Right. But this case is still ongoing. That said, look, I think we're going to prevail on this one. I think our arguments are very strong, and so we'll see what happens. I'm going to quickly move on to the next issue, which is the issue of Mr. Whitaker, and this will be a shorter discussion of him. As you know, Attorney General Sessions resigns, essentially facing either he'd be fired or resigning. And Matthew Whitaker, Chief of Staff, was appointed as acting Attorney General, which raised a lot of questions right away. So just a little bit of background. So, as you all probably know, to become Attorney General, you are nominated by the President. Congress, the Senate, has to confirm you. That's how it works, right? And there are certain folks within the Department of Justice who also are confirmed by the Senate. The Deputy Attorney General, Rob Rosenstein, for example, is confirmed by the Senate, right? They've gone through a process, high-ranking folks there. The Chief of Staff, Mr. Whitaker, has not been confirmed by the Senate, didn't go through any process. That Chief of Staff was just, the President had the authority to appoint a Chief of Staff. He put him in there, but Whitaker did not go through some formal process through Congress. And so the question became, hey, can the Attorney General, can Whitaker be the Attorney General if he's not been confirmed by the Senate? Can he actually, is he constitutionally the Attorney General or not? It's kind of a serious question. So Matthew Whitaker, as you've no doubt seen from many news articles, stepped in that role and raised all sorts of issues. So the state of Maryland has a lawsuit against the administration on totally different, they just have an ongoing piece of litigation against the administration. What they've done is they amended their complaint, they amended their lawsuit to include, after Whitaker being the Attorney General, the argument that, hey, this fellow Whitaker isn't really the Attorney General. He can't be signing documents in this case, he can't be making decisions in this case. Hey, federal judge, we're in litigation with the federal government, you've got to tell the Department of Justice, this guy isn't really the Attorney General and can't make decisions, can't sign documents, okay? It's like my name is on everything the state of Washington does, Robert W. Ferguson, right? My name's on the Attorney General. If I wasn't really the Attorney General somehow, right? I'm an evil twin in the Ferguson family, right? That can have all sorts of implications for all the cases we bring, criminal cases that we bring, for example, right? These things are, it's very important that folks have the authority to bring these cases because people's personal freedoms at stake, their business licenses, their personal freedoms, money, you get the idea, right? A lot's at stake. And so it's not an academic argument. It matters a great deal whether or not an Attorney General at the state level or at the national level really has the authority to execute the considerable powers of that office. So I've just got a couple of slides on this. So the only perhaps more dry than the Administrative Procedure Act is the Appointments Clause of the Constitution. But here it is. It matters for who your Attorney General is. And one thing I'll just maybe put a side message here is that, and I may have even said this before here at the Foley Institute, is that the law is fascinating in a lot of ways, but it is. I tell my team all the time that yes, of course, in these cases we are talking about the APA or we're talking about the Appointments Clause. But it's important in the way we communicate about our cases, the way I talk about them, and the way we brief them. It's important to remember that people's lives are really impacted by all these cases in dramatic ways, or our environment. Many of our cases are related to the environment, right, or our environment. But there are huge implications, and people's lives are being impacted by all these decisions. And that we can't ever lose sight of that. That yes, it's easy to get caught up in these seemingly arcane constitutional provisions or federal laws, but it's important in all of our lawsuits, to me, to tell a story about what we're doing and why we're doing it. We bring a case on behalf of dreamers. We've got declarations from many dreamers. We filed a lawsuit about the family separation at the border that was going on. We had declarations from many, many dozens of parents who were separated from their children for many, many weeks, if not months, and not allowed to speak to them and had no idea where they were. We're not just making arguments from a legal standpoint. We are communicating to the court, here are the people, here are their voices, right? Their declarations being signed, and they're impacted by it. They just put that out there for whatever, career for the students that you guys choose to do. I don't think it's just important in the law, by the way. I think it's important in all sorts of areas to just don't lose sight of that, right? That what a very important voice is in my line of work are the people who are impacted by it. But here we're talking about the Appointments Clause of the Constitution, Article 2, Section 2, Clause 2, kind of easy to remember. It's called the Advice and Consent Clause. I think I earlier referred to the advice and consent of the Senate. And what the Constitution says, in essence, I think I got it quoted there, but in essence it says for principal offices, Attorney General being one of those, obviously, one of the biggest offices we have in the country, for principal offices, the President must get the advice and consent of the Senate. In other words, the President can't simply pick the Attorney General and put him or her there. It goes through a process. And the rationale, if you look back at the framers and why they put this in place, it probably won't be a surprise to you, but the idea was they were very, very focused on making sure the President was not a king, making sure there were checks and balances, that there was not too much power put in the executive branch or the judiciary or the legislative branch, right? Co-equal branches of government. That was the idea. And they put together all sorts of things in place to ensure that as best they could. And the more we go on as a country, the more it's pretty amazing how they did it, really, when you think about it. And this is an example. They realized, well, wait a second, the President just appoint whoever he or she wants to all these principal offices. That's a lot of power, right, in one person. And the Senate, we've been locked out of that, and we're not so sure that's a good idea. Let's make sure that at least for these really big positions, the President's got to go to Congress. So that President's not just appointing people there who may not be so good for the country, and we want to make sure the Senate's weighing in. And this is one of those offices. So it's basically a check and balance on the executive branch placed into our Constitution. So again, principal offices, that's the Attorney General. No one, I think, really disputes that, and have to get the advice and consent. Now, there have been federal statutes put in place, just like lots of constitutional provisions. There are then federal laws that get put in place to figure out the mechanism for doing things, right? And we have that for the Attorney General. There's literally an Attorney General succession statute. How do we do this, right? Who can become the Attorney General if the Attorney General leaves office? And this has been, this statute's been in place for well over 100 years. I think it says over 150 years, a long, long time. Statute's been amended over time, right? But basically enacted 150 years ago, and that's when the Justice Department was first created. Justice Department was created after the Attorney General was actually established. And it says, what it currently says now is the Deputy Attorney General is the first in line for succession. So you think that'd be pretty airtight, right? Right? That, hey, we've got a Constitution and we've got this. The argument that the federal government is making is, great, you got that Constitution. Great, you've got that AG succession statute that does sound pretty specific, but we've got an argument around that, okay? And the argument, and there are other arguments, but this is, I think, is a key one here, is they say, hey, in 1998, another federal law was adopted, the Vacancy Reform Act, the VRA. And this is a sort of general statute about how vacancies are filled. So what they're arguing is, hey, this essentially supersedes earlier statutes. Now, look, we think there's a lot of problems with that. Just at a high level, what I would say is that it's sort of a relatively basic principle in the law is if you have a very specific statute about something, very explicit, and later comes a general statute, that general statute does not supersede this very specific one. Okay, if you've got something very specific in place, people must put a lot of thought into that. A general one that comes along doesn't replace that, okay? So our view is, great, Vacancies Reform Act, there's lots of vacancies that go on in federal government, that applies to those, but it does not alter the Constitution or the very specific AG succession law that's been in place now for a long, long time. But that'll be a big part of what the argument is about. I guess what I'll kind of, as I start to wrap up, what I'll say is that, I'm often asked on the cases we bring, I get asked a lot of questions about the federal judiciary, the makeup of the U.S. Supreme Court, changes in the judiciary with this particular president. Hey, each president appoints their people, right? I mean, but the changes that come along with that, what does that mean for our cases? I'm asked that all the time, and I don't want to understate how important certain changes in the Supreme Court are, for example. Obviously, they're important. But what I will say is that in our cases, we believe that our arguments appeal to judges of all judicial orientations, okay? If you're talking about the Administrative Procedure Act, that is not some political, right? Either you notified Congress or you didn't, right? I mean, it's not like it doesn't get too complicated in a certain sense, right? Now, that's not true for some cases, obviously, right? A judge's orientation is going to have a huge impact, but sometimes those orientations might surprise you. So, for example, on this issue of the Appointments Clause of our Constitution, I was doing some research on it, as you might imagine, and reading about it, and a year ago, there was a decision by the U.S. Supreme Court, and it was about an appointment to the, I think it was to the National Labor Relations Board. I'm pretty sure I've got that right. It was just last year. I'm almost positive it was just last year, and it was about an appointment to that board. Things like for their general counsel or something like that. And the court made their decision based on a federal statute. Clarence Thomas wrote a concurrence. So he wrote an opinion saying, hey, I agree that the majority's got that right, but I want to add some thoughts to this conversation. And what he wrote, I wish I had the quote memorized, I'm sorry I don't, but he wrote a concurrence saying, you know what also applies here is the Appointments Clause. And what he wrote at length about was the Appointments Clause, I'm putting this in papers, I'm paraphrasing, matters a lot, everybody. Appointments Clause is really important. Don't forget about the Appointments Clause. I really think the Appointments Clause is this robust vehicle. Don't go around violating the Appointments Clause, right? He wrote he cared so much about it, he wrote a separate opinion, even though he agreed with the majority opinion. I will be fascinated if this case gets before the U.S. Supreme Court, and I think a case like this, either this one or another one, will end up before the U.S. Supreme Court. They've got to resolve whether Whitaker is the Attorney General or not, for all the reasons I mentioned. Cases are happening every single day with the Department of Justice. If I had the money right now, Clarence Thomas, given his views on the Appointments Clause, I kind of think he's going to be with us, right? Would I say that about every case we have necessarily? No, maybe not. But what my point is, you can't read too much, and you can't just make a knee-jerk reaction. You can't have a knee-jerk reaction based on what you think a judge's or justice orientation might be. And that's the beautiful thing about the law, right? On the first travel ban case, we won the trial court, we won the Ninth Circuit Court of Appeals. The administration, people forget, did not appeal to the U.S. Supreme Court. They scratched that first travel ban, which applied to people with green cards, for example, which is crazy, right? People with green cards here legally have gone through a process, and they put a more narrow travel ban, and a more narrow one after that before they got through the Supreme Court. But on that first travel ban, they did not appeal to the U.S. Supreme Court, even though one might think they had a sympathetic Supreme Court, right? They didn't. I'll tell you one reason why they did not appeal that case. They would have lost, and they would have lost badly. There are justices who are of a conservative orientation, putting that in quotes, right, who I have zero doubt, in my mind, would have ruled in favor of the state of Washington against the president. And the Trump administration clearly believed that, or they would have appealed it. They said, nope, we're just gonna scratch this one and try and redraft a more narrow one that might have a better chance of success at the U.S. Supreme Court. So, in thinking about our cases, yes, of course, as we craft our arguments for different judges, or the Ninth Circuit, or the Supreme Court, yes, of course, you're aware of the judge you have and what their backgrounds are. But one thing I would emphasize is those views of those judges might surprise you. And no, we don't get to pick our judges we're in front of. We file a case, it's a random selection from whatever bench you apply to, whatever district you apply to. We've been in different courts across the country. So far, not one federal judge, whether appointed by a Republican president or a Democratic president, has ruled against the state of Washington on the merits of any of our 32 lawsuits. Not one. We've had a lot of trips to the courtroom in the last 2 years, right, in front of a lot of different judges who by any measure have a wide range of of judicial orientation, by any measure, and yet not one has ruled against us. Now look, that won't last forever, right? But I think it's an indication that the rule of law really is a powerful thing. I think the people on the federal bench take that very seriously, regardless of who the parties are. And I think that's why we'll continue to be successful as well. So I'm going to stop there, and it looks like we have about 20 minutes or so for
Great,
questions.
yeah.
So Cornell, should we just dive in with questions?
Just dive in, yeah, maybe I'll start us off.
Okay, he always gets to the first one. So, all right, yeah, the softball comes first. All right,
So
right. I'll try and repeat the questions so folks can hear it. Yeah.
So I want to ask you about the Whitaker thing,
Yeah.
because OLC's opinion argues that he's not a principal officer because he's temporary. So what's your argument against that?
So the argument is that, hey, he's not really a Whitaker, for this is the Whitaker issue. He's not really principal because he's temporary. Couple things about that. So number one, of course, it wasn't like Attorney General Sessions just walked out the door unexpectedly, right? I mean, all serious, right? I mean, the president created a situation by which he had to leave. So he's created the vacancy, essentially, the president has, and there is no sense at all that he has anyone lined up to replace him at all. And so we do not believe that if you have some exigent circumstance, and there are some cases where an exigent circumstance, especially way back, I think in the early 19th century, there are certain exigent circumstances, horse and buggy days, where, okay, you might need someone there on a temporary basis till Congress can convene or something could happen. We don't think this meets any of that, in part because the president clearly created the situation, is not going through any process to replace him. He's just there, as far as they would tell, making decisions indefinitely. So I do not think that's going to, I mean, they'll make that argument, I think, but I don't think it'll be successful. Yes?
What's the point in making 3D guns illegal if you're able to just use Tor and a VPN to get the program anyway and get it 3D printed? And like, if you're going to break the law and try to 3D print a gun when you're a felon, it should be easy to pirate as well.
So the question is, why, I guess, why make it illegal, I think is the question, 3D guns? Is that the question? Why make it illegal?
If it's going to be acquirable anyway, just as easy.
Well, I guess first, I mean, I think the folks who can answer that is the federal government. They're the ones who make the laws, who say it's illegal. I'm not the one who say that there are federal statutes out there saying it's illegal, right? So that's not me necessarily. That's my job is to enforce the law, right? And so I'm not the one sort of making the law, so to speak, right? But I think and also keep in mind, just because someone can circumvent the law doesn't mean you should not make it illegal, right? So yes, can folks on the dark web, can you find ways to access this information? Yes. You know what you're doing, you can access it. That doesn't mean we should just make it legal because, well, my God, some people can access it, so hell, let anyone post it up there, right? I don't think that's the way the federal government's thinking about it. I think what they're thinking is, let's make it as difficult as possible, right? So someone who's a domestic abuser, not allowed to have a gun, who wants to go after their victim, can't just go on the internet, punch in some things, Defense Unlimited, whoa, there it is, press some buttons, and then they've got a gun, right? Make them work a little harder if they're going to circumvent the law. So I don't think that can be the argument either. But again, these are federal laws and rules that are in place, right? Some people say, hey, it's the First Amendment. He's arguing, by the way, is that it's a First Amendment thing. The web, we should be able to post whatever the heck we want. That's essentially his argument. Great, he can make that argument, but again, we have federal laws in place, right? Notice to Congress, concurrence from the Defense Department. That hasn't happened. And so sometimes in a lot of my cases, a lot of cases around immigration, for example, or Dreamers, look, am I aware that there is a big policy debate around immigration going on? You bet. Is that my focus? No, right? I'm not in Congress. I'm not the president. My job is to enforce the laws that currently exist. If the federal government wants to change those laws, right? If Congress wants to go and change those laws, say, yeah, you have to notify us if you want to change this. You have to get the Department of Defense to approve it. Federal government, president, if you want to change it, knock yourself out. If they want to do it, okay, I may not agree with that. Which also goes back to my 3 questions, right? Trust me, there are plenty of things the administration does when we have our weekly meeting as a team and we're going through whether we're going to litigate, where I have a strong disagreement with what the administration is doing. But we're not bringing a lawsuit because I don't think it's illegal. I may really disagree with it, but that's not my lane, right? That's your member of Congress. That's the Senate. That's somebody else, right? So I focus on what is enforcing law when the administration is not following their own rules. Yes?
What's the logic behind creating a civil rights division in the Washington AG's office? I mean, that was traditionally a federal responsibility, and what's your read on
Sure.
why create that unit? And I think it's a good idea,
Yeah.
but I would like to hear the logic behind it.
So the question goes to, why did I create a civil rights unit in the Office of Attorney General here in Washington State? That, hey, is that sort of typically a federal enforcement issue? It is often, we have federal laws, right, on civil rights, but Washington State has its own specific anti-discrimination law. So we have a state law. So the Attorney General can enforce that state anti-discrimination law. And despite having that authority, we've never had the personnel to do that. We just never had lawyers or professional staff who could bring those cases. And going back at least 50 years, I should say. In the 1950s, it looked like the AG's office did affirmative civil rights work on behalf of the people. In fact, a fellow named Wing Luke. If you've ever been to Seattle, there's the Wing Luke Museum in International District, a place you should check out, by the way, if you're ever there. Wing Luke was an assistant attorney general in the Office of Attorney General. In fact, he was there with Tom Foley. They served at the same time. In fact, I've got something in our office where they were both hired on the payroll at the same time, 1960 or something. They were both AGs in our office. Wing Luke was a civil rights attorney, later got elected to Seattle City Council, first Asian American elected to office in the Pacific Northwest. He was really a civil rights trailblazer. I'm digressing a bit, my apologies. And then he, but I'm a real admirer of his, and he died quite tragically in a plane crash when he was a young man in his first term on the Seattle City Council. He was a brilliant guy. Wing Luke, you should Google him sometime. And so back in the 50s, and that was like fair housing issues, right? There were cases about that the state, we had state laws related to fair housing that Wing Luke and the Attorney General back then argued for a state Supreme Court. But the 50 years have gone by, or 60 years, where we had not been enforcing those. Now, when I created that unit back in 2014, maybe, I got elected in 2012. That was obviously long before Donald Trump was running for president, or obviously the president. So that the impetus was simply to enforce our state laws. Now, with the first travel ban and some of our issues we've had with the administration, a lot of folks in that civil rights unit have been key resources for me in bringing different lawsuits. And so the way I look at it in simple terms is we're the largest law firm in the state of Washington, AG's office. We've got about 600 lawyers, about 500 professional staff. We've got offices all around the state. We've got one here in Pullman. We do every kind of law you can imagine and many kinds of law you cannot imagine. And yet, when I became Attorney General, I realized one area of law we did not do was civil rights work on behalf of the people of the state of Washington. That doesn't make any damn sense to me, right? And so I created resources where we could create that unit. It's been growing. We're up to about maybe 8 or 9 attorneys, about 8 attorneys right now, and growing. We're hiring more. Yeah, thanks. Yeah. Yes?
I'm going to preface my question by saying I'm a big admirer of almost everything your office has ever done.
I'll take it.
But there's one case I'd like to ask you about. I lost my best friend in the Oso landslide in western Washington. And as you know, DNR was accused quite credibly of management practices at the top of that landslide that clearly contributed to that landslide. I have a forestry colleague who verified that to me himself personally. My friend's widow organized the class action suit against DNR and against the German landowner that also had some land up there, and organized that lawsuit. And as I understand it, your office hired an outside attorney to handle it because it was a big case. And according to the information that I've had, that attorney who was hired deleted some emails, which the judge apparently saw as destruction of evidence. And so the people had to sort of relive their whole experience of having gone through that landslide again in putting together the case. And then the case was not settled until the first day of the trial. So I have 2 questions for you about that. One is, why didn't you settle with them a heck of a lot sooner and not put them through all of that agony? And number 2, do you think they would have gotten the level of settlement they did get if they didn't go to the trouble to hire a very competent and very expensive law firm to advance their cause?
Yeah, so good question. So first, I'm really sorry about your loss. I went to the site to visit it. Yeah, right. And so just by way of background, as you know, we defend the state. The state is sued. We have a torts division. So if the state is sued in any capacity, huge case like this one with massive loss of life and property, in a huge case, we defend the state. If it's a small case where one individual is impacted on a slip and fall on state property, we defend the state. That's the job. That's the job description. On this case, to your point, so hey, why didn't this case settle earlier? I mean, all I can say is it obviously takes 2 sides to reach a settlement, right? And so I do have an obligation as the Attorney General in reaching a settlement that I think is fair for everybody. fair for the taxpayers, all of you who are paying for that, right? And fair to the other party as well. Sometimes plaintiff's attorneys say, yeah, we're going to trial, we'll see you in court, okay? But there's nothing to settle then, right? Sometimes there's dollar amounts put out there and we think, well, yeah, we're prepared to pay many millions, of which we were. They may want more. I'm not saying that's unreasonable, but it's a settlement. Both sides have to agree on what that is, right? So I guess I just wouldn't confuse not wanting to settle a case, which I can assure you would have liked to have settled that case, right, with reaching a settlement that we think is fair for the taxpayers and for the harm that was done, the damage that was done, right? Number two, on the issue of the attorney, so yes, there's an attorney hired outside the office, not unusual at all. It was not just that attorney. We had lawyers in our office who were handling the case as well, but there was added personnel because the case was so large, who did exactly what you said, which was a black eye for the agency by any measure. There are no two ways around that. The plaintiffs have to sort of redo their case. We paid a hefty, not penalty in the number sense, but there was, look, it did not help our case that had happened. Once it came to my attention that this had happened, we cooperated with the court, with the plaintiffs attorneys, hired someone to go back and retrieve as many of those emails as humanly possible, according to the court. And when the court issued its sort of decision on that, they did point out that we cooperated fully once it came to my attention that this had happened by this attorney from outside the office, right? That we cooperated with plaintiffs' attorneys, that we provided all the information we possibly could and retrieved them. That doesn't make it right, what he did. He had his reasons for it. He felt he misunderstood what the rules were. We think that's a pretty lame excuse, honestly. And so we have taken steps within the office trying to avoid that from happening again. At any particular time, we have thousands of legal matters pending. They're not all equal in importance, right? And this was a big one, and so it's especially the kind of case where there should not have been a mistake. The mistake is short selling, right? But a mistake of that magnitude. So in the end, there was a resolution, obviously, as you know. So I'm often asked, hey, Bob, why don't you settle X case? Sometimes I know the other side doesn't want to settle, they're just going to trial, right? But I'm not really at liberty to talk about what dollar amounts we put over, and right, that's, those are confidential exchanges. But in general, it's often where the two sides just don't agree on a number. We're going to trial with Comcast on Monday, but both sides have put significant dollars on the table, but they've not put on enough for me to settle, right? It doesn't mean they're not trying to settle the case, we just can't reach a number that we all think is fair. Thanks. Yes?
What's the legal argument behind the transgender lawsuit, the transgender military ban lawsuit? I'm just curious about that. Is it more administrative, or is there something to do with the Constitution? Like you talked about the
Yeah.
Is it constitutional, some equal protection?
Yeah, the question goes to transgender military ban, which is a really fascinating case, but I'll give you a relatively short answer now. And so that, by the way, is a case that Washington filed in Seattle. Okay, I don't believe other states are on that, which is a little bit unusual. That's one that we filed here in the Western District of Washington. We were the first state to challenge it. And that one's a little bit unusual in that the president, of course, issued a tweet saying, hey, we're not going to allow transgender individuals into the military. We challenge that on some of the things you're talking about, right? Constitutional grounds, right, for transgender individuals who are, in our view, fit to serve. What's happened in that case is we've said, hey, that there is no rationale for the federal government's policy. What happens after we filed a lawsuit, the federal government actually adopted a study, right, that they tried to bootstrap into the litigation. Say to the court, hey, see, we got this study here. Our response is, well, great, you've done that study, but you did that after the president issued his tweet saying, here's what we're going to do. The federal government says, well, hey, that tweet isn't really an executive order, it's not really an action, you get the idea. It gets complicated in a hurry. But yes, from our standpoint, from a civil rights standpoint of folks who have been serving our military, right, serving well, that you simply can't just undo that without any due process, right, without any evidentiary support for why someone who's a transgender individual can't serve in the military in any way different than you or me or anyone else here in this room. And so we've been successful in that case. We won at the trial court. We got a restraining order, I should say, just like this 3D gun case, a restraining order at the trial court. The administration appealed that to the Ninth Circuit Court of Appeals. A 3-judge panel heard an argument on that just in the past month or so, and we'll see what happens. Maybe time for one more. We're kind of getting down to it, right? Well, maybe I'll try and get to it, but go right ahead. Yeah, I'll go quick. We'll see
Yeah,
what
just if you could give us an update on what's going on with the cannabis laws. I know
Yeah, sure.
it's something that's really low federal level with people on our state.
Yeah, so marijuana laws, I'll give you the quick lowdown on the state of marijuana laws. Obviously, as you all know, Washington State legalized marijuana. We were the first state, along with Colorado, legalized back in 2012. Other states now, I should know how many, but a number of states have now legalized marijuana across the country. Red states, blue states, you get the idea. My job is to defend the will of the voters through the initiative process. If they pass an initiative, we defend it. Couple thoughts about it, I guess, at a high level. So one is, obviously, Washington has had a system in place now for a number of years. And no system is perfect, but it seems to be working well. And the federal government has so far not challenged them. I had some concerns when Jeff Sessions became Attorney General. He was very vocal in his opposition to the legalization of marijuana. I asked him for meetings, I did not get them. So I had some concern that he may initiate some kind of legal action against Washington or other states. He's obviously no longer there at the Department of Justice. So we'll see with the new Attorney General if that changes. But my view is that each month, each year that goes by, without the federal government trying to stop the states from legalizing marijuana, makes it exponentially more difficult for the federal government to ever do it. For the simple reason that now more and more states are legalizing marijuana. Like I said, red states, blue states, you name purple states, they're just doing it. And so I think that just this is not a legal answer now so much as a political one, right? I just don't see how any administration now is going to undo all of that. And if Jeff Sessions, who had very, very strong views about it, wasn't going to be the guy to do it, I kind of don't see it happening. Now look, who knows, I could be surprised, but if that was to happen, we would obviously defend the will of the voters and say that Washington can go forward legalizing marijuana, but hopefully we won't get to that. All right, well, one last question, then we'll wrap it up.
I was just wondering if in Washington and other states around the country, all the additional legal actions that have been taken by states against the federal government is how much that's costing all the states.
Sure.
And how it has shifted your attention away from other legal work in the state.
Sure. So the question goes, I can't speak to other states, but for Washington, hey, how do we pay for this litigation against the administration? How does it take away from other work that we do? The good news is that it doesn't cost the taxpayers anything. When I mentioned the Civil Rights Unit, for example, if you look in the state budget, these are the folks who do the bulk of the work. There's no budget line item for the Civil Rights Unit. There's no taxpayer dollars that pay for their salaries, for the lights of their office space, for the travel, nothing at all. My Consumer Protection Division, which also is involved in this stuff, same thing. There's literally no money in the general fund, taxpayer dollars, that fund any of the 100 or so people working for consumer protection or the 8 or so lawyers and additional professional staff in civil rights. The way those operations are funded is that in our Consumer Protection Division, which files litigation against powerful interests and always play by the rules, Comcast, big trial coming up, when we resolve cases, we put many millions of dollars back to consumers who are harmed. We send many more millions back to the state of Washington, but those recoveries fund the operations. So literally, there are no taxpayer dollars. Now look, is there the occasional attorney at the University of Washington division who helps us get a declaration for a travel ban lawsuit? Sure, but it's essentially nominal. And also keep in mind, if we are, in many of the lawsuits, we are supporting other states, we're not taking a laboring oar. The work there is truly de minimis. So when Rob McKenna was asked this question when he challenged the federal government, Barack Obama's administration on Obamacare, he was asked by Democrats, hey, how much money are you spending? He said, look, it's another state leading, it's really no funds at all from the states. Even on the issues where we lead, though, the bulk of the work is done by the divisions that have no impact on the taxpayers at all. Even if there was an impact, I think it's a good use of the resources. And number two, you're asking, hey, does it take away from the other work? No. And as the question earlier, I created a civil rights unit, did not exist before I was Attorney General. So the good news is we're actually doing more work. We're holding the Trump administration accountable, and the civil rights team is bringing other statewide civil rights cases as well. The consumer protection team, when I started, had 10 or 11 attorneys. Now they have 28. There's just more people doing more work, so I've reinvested more of those recoveries back into those operations. So I can assure you, we have more resources, not less, for the work. So there's no takeaway from the other work of their office. Now, in fairness, is part of my time spent thinking about the Trump administration in these cases that isn't spent on something else? Sure, but hey, for a long time, I spent a lot of time thinking about the OSO situation where I was personally involved, and I can assure you, a lot of my time for about 6 weeks was every single day, hours of every day, focused on the issues you raised. Yeah, you bet. That's just the nature of the job, right? There's different things that become high profile at any particular time. Sometimes it's on the defense side, something's gone wrong in the office, sometimes it's on the affirmative side. So thanks for the questions. Just to wrap up, I just appreciate all the questions. It's great to be back at the Foley Institute. We're proud of the AG's office that he worked in our office for a while before he went on to a great career. Thanks, you guys. Go Cougs.